Good. Record will reflect that we're in session outside the presence of the jury in the state of Wisconsin versus Kayle Fleischauer. The appearances are as previously noted. Over the evening hours, counsel, I did revise both the verdict forms as well as the instructions. And hopefully you found on your tables the final versions of both. The verdicts that will be provided to the jury will read as follows. We, the jury, duly impaneled, as and for our verdict in the above captioned matter, find Kayle Allen Fleischauer guilty of second-degree reckless homicide, contrary to Section 940.06 Wisconsin statutes as charged in the information. And we, the jury, duly impaneled, as and for our verdict in the above captioned matter, find Kayle Allen Fleischauer not guilty of second-degree reckless homicide as charged in the information. As noted, the court has removed the special question from verdict 1, given the request yesterday that issue will be, in essence, presented to the court after a return of a verdict, if that determination is necessary. Any objection to the proposed verdict forms, Mr. Kaiser?
No.
Mr. Gray?
No, Your Honor.
Thank you. Likewise, as indicated, the court has drafted what it believes are the final version of the instructions. And again, following sequentially, there will be 100 opening, 1060, second-degree reckless homicide. I have removed the instruction on the special question. 140, burden of proof and presumption of innocence. And counsel, as you'll note, the last paragraph of that instruction is an earlier version of that particular instruction. The court believes it is a better read relative to the search for the truth and how that fits with the reasonable doubt standard. So while it is not the current version of 140, it is a version that was used for many, many years, and I'm satisfied is a better reflection of the law. 145, information, not evidence. 103, evidence defined. 170, circumstantial evidence. 154, summary of evidence. 175, and I did modify what was requested by the state. I took off the last two sentences because I didn't believe it made sense, because there is no proof of motive, and the last two sentences refer to if motive has been proved, or proven, I guess, grammatically correct. So those two sentences have been removed. 161, agreed testimony. 162, agreed facts. 157, remarks of counsel. 155, exhibits. 158, recordings played to the jury. 148, objections. 147, improper questions. 150, stricken testimony. 190, weight of evidence. 195, jurors' knowledge. 300, credibility of witnesses. And Mr. Gray, I have included 315. I know you're going to talk to your client, and I did, counsel, go online and found what is the 7th Circuit Court of Appeals instruction on defendant election not to testify, and I'll change defendant to election not to testify to eliminate that particular label. And so the instruction has been modified to include, you should not even discuss it in your deliberations. Remember that it is up to the state to prove Kayle Fleischauer guilty beyond a reasonable doubt. It is not up to Mr. Fleischauer to prove that he is innocent. Again, that's the 7th Circuit instruction, and I think is consistent with what Mr. Gray had requested. So given that modification, Mr. Gray, are you now requesting 315?
Yes, Your Honor.
Thank you. Court will then include 315 as modified. 180, statement of Kayle Fleischauer. I know that Mr. Gray had objected yesterday to the 3rd bullet point. However, I reviewed the instruction, I reviewed the comments, the case law, and I'm satisfied that that is an accurate reflection of the law in Wisconsin. And certainly there are portions, I believe, of Mr. Fleischauer's statements that both sides may wish the jury to ignore or to accept. So I think it arguably cuts both ways in terms of that particular reference for the jury to review. 755 is a modified intoxication instruction, drawing on the pattern, but more so just common sense in terms of how intoxication does not fit relative to the elements of the crime. 605, instruction on the issue of Kayle Fleischauer's mental condition, given the testimony by Dr. Dunn yesterday. The court has included that instruction so that the jury understands how that particular testimony fits within the narrative of this trial. 200, opening opinion testimony. 205, hypothetical questions. 160, closing arguments. 460, closing instruction. 482, verdict submitted. 515, unanimous verdict and selection of presiding juror. And you'll note, counsel, I've included paragraphs regarding the alternates. This morning I had the clerk tumble, and at some point she'll deliver to me the two jurors who have now been determined to be the alternates, and that's done through a random tumble of all 14 names, and all 14 have reported this morning. Upon return of the verdict, the court will give 525A instruction after verdict received alternative. Any objections to the proposed instructions, Mr. Kaiser, or additional requested?
Judge, just in terms of 315, we did do some research last night and found Federal 2.05, which does read, a defendant has an absolute right not to testify. You may not consider in any way the fact that the defendant did not testify. You should not even discuss it in your deliberations. Based on that research, we didn't foresee the last two sentences. I can't say that our research told us that that was specifically the Seventh Circuit version, but our position would be that since what we were agreeing to was the federal rule or the federal instruction, and that's the one we found, that the last two sentences are an unnecessary repetition of what's already in the burden of proof instruction.
Mr. Gray, I know that you had submitted something, I think last night or early this morning, which again did not include the last two sentences. As I said, I did that after reviewing a number of iterations. The Third Circuit had a variation, the Seventh Circuit, the 10th Circuit. So I have no heartburn in taking it out, and I think it reflects in essence what you had submitted this morning.
Yes, Your Honor, I asked it to be kept in. It's the law. So.
Well, what I'm asking about are the last two sentences.
Yes.
Comfortable with striking that?
Am I? No. No, I won't request it.
Your Honor, we didn't see defense's request this morning, but in any event, what we were told we would be looking at is the federal instruction. We found it. That's one we thought was being given. That's one we agreed to, and that's one we asked be given, which is essentially everything you have written except the last two sentences.
I did not agree to any. I mentioned the federal instruction yesterday that it had that in there, but I never agreed to the federal instruction from the Seventh Circuit, the Eighth, or any circuit. And each circuit's different. This is the law, and the court's put it in there, and I request that it stay.
Thank you. Again, while it in essence captures what was in, I believe, 140, the burden of proof and presumption of innocence, I am satisfied that it fits. And as I said, if the Seventh Circuit believes that it's a reflection of the law, I'm comfortable with giving it as I have provided. Mr. Gray, any objection to the proposed instructions or additional requested?
No, Your Honor.
Thank you. Counsel, jury is here. I told them to get themselves settled, use the facilities, and as soon as they're ready, we'll bring them in. And they will have copies of the instructions in their hands to read along with. And as soon as I get the tumble, I will insert that obviously in my master copy, and no one will know that until we are ready to discharge the jury. Thank you. We're adjourned.
Judge, I have two questions.
Yes, Mr. Gray.
One, you do give a copy of the instructions to the jury?
Yes.
And two, I don't remember, do you read the instructions before argument?
Correct. In fact, you should see, I believe it's on page 4 from the back. I read the majority of the instructions, and then you'll argue, and then I give the closing instructions afterwards.
Thank you.
Thank you.
I think we're gonna put it, hey Judge, we have another, medical board, can I just put it in front of the witness?
Yeah, because we're not going to be using it. I just make sure that I have clear vision or clear line to the jury. Please be seated. Good morning, ladies and gentlemen of the jury. Record should reflect we're in session on State v. Kayle Fleischauer. Appearances are as noted. Ladies and gentlemen, as you know, we're now going to proceed to the final phase of this trial, which will be the instructions that I will read to you. You also have courtesy copies if you wish to follow along. Near the end of those instructions, the attorneys will then make their closing arguments. And once the arguments are done, I will then give you some closing instructions. With that said, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial, and the law is given to you by these instructions, and from these two sources alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Kayle Fleischauer is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The information in this case charges that on or about Saturday, April 14, 2018, in the town of Richmond, St. Croix County, Wisconsin, that Kayle Fleischauer did recklessly cause the death of Chase Fleichauer, contrary to Wisconsin law. To this charge, Kayle Fleischauer has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Second-degree reckless homicide is defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. Before you may find Kayle Fleischauer guilty of second-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, Kayle Fleischauer caused the death of Chase Fleichauer. Cause means that Kayle Fleischauer's act was a substantial factor in producing the death. Second, Kayle Fleischauer caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Kayle Fleischauer was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. If you are satisfied beyond a reasonable doubt that Kayle Fleischauer caused the death of Chase Fleichauer by criminally reckless conduct, you should find Kayle Fleischauer guilty of second-degree reckless homicide. If you are not so satisfied, you must find Kayle Fleischauer not guilty. In reaching your verdict, ladies and gentlemen, examine the evidence with care and caution. Act with judgment, reason, and prudence. Persons alleged to have committed a crime are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that Kayle Fleischauer is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state of Wisconsin. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Kayle Fleischauer is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Kayle Fleischauer's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt, ladies and gentlemen, means a doubt based upon reason and common sense. Again, ladies and gentlemen, the term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of making a decision. While it is your duty to give Kayle Fleischauer the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Kayle Fleischauer the benefit of a reasonable doubt if it arises in your minds after you have carefully considered all of the evidence in the case. And information, as I instructed you last Monday, is nothing more than a written, formal accusation against a person charging the commission of one or more criminal acts. You are not to consider the information as evidence against Kayle Fleischauer in any way. It does not raise any inference of guilt. Evidence is defined as follows. First, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness to testify. Second, exhibits the court has received, whether or not those exhibits go with you to the jury room. Third, any facts to which the lawyers agreed or stipulated, or which I have directed you to find. Anything you may have seen or heard outside of this courtroom is not evidence, and you are to decide this case solely on the evidence offered and received during this trial. It is not necessary, ladies and gentlemen, that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by what is called circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. However, whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Kayle Fleischauer committed the offense before you may find him guilty. The court has allowed the use of certain exhibits to organize the evidence and to assist you in understanding it. The summaries themselves, however, are not evidence. It is a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the summary exhibits only to the extent that you believe they accurately and properly summarize the evidence. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a person alleged to have committed a crime, the state is not required to prove motive on the part of Kayle Fleischauer in order to convict. The attorneys for the state and the attorneys for Kayle Fleischauer have stipulated or agreed that if certain individuals had been called as witnesses, they would have testified to certain facts. You will consider that agreed upon testimony in the same manner as if it had been given under oath here in court. Likewise, the attorneys for the state and the attorneys for Kayle Fleischauer have stipulated or agreed to the existence of certain facts. Again, you must accept these facts as conclusively proved. Remarks of the attorneys made throughout the trial are not evidence, and if the remarks suggested certain facts not in evidence, disregard the suggestion. Exhibits become evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence, again, whether or not it goes with you to the jury room. You have heard audio recordings during the trial. Recordings are proper evidence, and you may consider them just as any other evidence. The recordings also included transcripts to help you listen to the recording. However, if you noticed any difference between what you heard on the recordings and what you read in the transcripts, you must rely on what you heard, not what you read. Attorneys for each side have the right and, in fact, the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that objections were made throughout this trial. By allowing testimony or other evidence to be received over the objection of an attorney, the court is not indicating any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. And if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, ladies and gentlemen, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. It is the duty of this jury, in fact, any jury, to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You, again, are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, you should consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, their appearance, and their demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness has testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way, ladies and gentlemen, for you to evaluate testimony. Instead, you should use your common sense and experience. In everyday life, Each of you determines for yourselves the reliability of things people say to you. You should do the same thing in this courtroom. A person alleged to have committed a criminal offense has the absolute constitutional right not to testify. Kayle Fleischauer's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. You should not even discuss it in your deliberations. Remember that it is up to the state to prove Kayle Fleischauer guilty beyond a reasonable doubt. It is not up to Mr. Fleischauer to prove that he is innocent. The state has introduced evidence of statements which it claims were made by Kayle Fleischauer. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. First, whether the statement was actually made by Kayle Fleischauer. Only so much of a statement as was actually made by a person may be considered by you as evidence. Second, whether the statement was accurately restated here at trial. And third, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statements deserve. Evidence has been presented which, if believed by you, tends to show that Kayle Fleischauer was voluntarily intoxicated at the time of the alleged offense. You are not to consider this evidence in deciding whether Mr. Fleischauer acted with the mental state required for the charged offense. You have also heard testimony about Kayle Fleischauer's mental condition at a time following the alleged offense. This evidence was offered with regard to Kayle Fleischauer's conduct and behavior following the death of Chase Fleichauer. You are not to consider this evidence in determining whether Kayle Fleischauer committed the alleged offense. It goes only to his state of mind and conduct after the alleged offense. Ordinarily, ladies and gentlemen, witnesses may testify only about facts. However, a witness with specialized knowledge, skill, experience, training, or education in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also, consider the qualifications and credibility of the witnesses and the facts supporting their opinions. During the trial, various witnesses were told to assume certain facts and then were asked for opinions based upon those assumptions. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. At this time, carefully consider the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions which have been given to you by the court. Mr. Kaiser will address you first, followed by Mr. Gray, at which time Mr. Kaiser has the option to give a rebuttal. At the end of those closing arguments, ladies and gentlemen, I will give you your closing instructions. Thank you. Mr. Kaiser.
Thank you, Judge.